SG Bora as per respondent number 2, Lordship. So kindly fix the matter on next Thursday. There is urgency on the appellant side.
Yes, my God.
A prayer for adjournment has been made on behalf of Miss H.G. Barwa, learned amicus curiae for the respondent number 2. Para. Matter is accordingly adjourned to be listed on Thursday next.
Next Thursday, 27. Much obliged.
Yes.
Master.
Lordship, I'm not prepared.
This otherwise also this that we are already in the midst of that separate. We'll I think defer this. We'll complete that first. That, in fact, that we have to have completed today, but Mr.
Yes,
Pothakur, who has some difficulty. Otherwise,
I madam. Last afternoon it would have been completed.
yes,
and then
yes.
There's another item, my lord, date reference. And registry should be directed to list one date reference.
Yes.
Your lordship will see at item 3 and 4 is also date reference.
Separate matters.
It's separate matter.
Not proper.
Yes, sir.
What about 3? 3 you are prepared or not, madam? No, no.
Not
APP.
Three and 4 is also debt reference.
Understood. But you prepare one properly and we'll try to have it on a date fixed.
Lordship.
And that those matters are fixed I think on Monday.
I have taken stock, my lord.
Monday, if Tuesday fixed করছেন। হয়নি?
Monday
Monday,
Tuesday?
Monday was
Monday,
said, probably it was taken Tuesday.
This is Tuesday, no? Okay, it's Tuesday.
What Tuesday?
hearing date.
Oh, hearing day, okay. Okay, then you tell us a date.
Well,
In
any
both the
date,
matters,
21st,
Mr. Kamar, you appear as the amicus.
Oh,
Both
yes,
the
madam.
matters.
Both the cases, my
Mr.
lord.
Bhuya in the first matter.
Yeah, yes.
Is there a separate appeal also by you? Yes,
Yes,
there's an
yes.
appeal.
Independent appeal.
And so for item 3 is concerned,
My lord, it is Mr. Sharma appearing for the appellant
As an
the
amicus.
query, my lord.
Okay.
We are amicus query in the date reference.
Understood. In both. Okay.
Yes.
Yes, tell us when.
21st.
After
First week of April.
first week.
You tell us, you have the different dates.
21 April করা
Yes, yes, yes.
After 21.
তার আগে ফিক্স করা আছে আর
ঠিক আছে।
আউটস্টেশন মেথড
No, you only
Okay, okay,
on
okay.
21.
My lord, he is seeking 21 April.
April
That
for
is
the
fine.
item
One
number
and
1 and 2
Okay, item number 1 and 2. On a joint request, the matter is adjourned to be listed on 21/4.
21 4, my lord.
21
Okay, hopefully, yes. And the other one,
Somewhere around 29, 30, my lord.
obliged
29, my lord.
Madam
April.
Sharma.
29 April, my lord.
Okay. On a joint request made by the learned counsel for the parties, list on 29th.
29.
Lord,
Pare ki baat? Tuesday.
29 letter,
29 is
April.
Monday,
Okay,
Tuesday, my lord.
Okay, 29 April. Okay.
My lord. Much obliged, my lord.
Item 5. Matrimonial appeal.
Lordship, my senior is on lake matter maybe pass over for timing, Lordship.
Who is your senior?
Lordship, advocate P.K. Deka.
Other side? Who is for the other side? Other side, I Alam, T Sheikh. Where are they? Time being may not be possible, but still then call them. If we are still sitting, then we'll take up the matter, okay?
Okay, Lordship.
I inform the other side also.
Obliged, Lord.
Item 7.
Against bail rejection.
Repeat the Lordship. Lordship, 2 years, 6 months behind the bar, Your Lordship, and two accused are already been enlarged on bail.
Lordship, DY is supposed to appear. I'm just calling him.
Please call him. Let us see the rejection order.
And next, Your Lordship, page number 16.
1-6.
Yes.
Raju Ali.
Raju Ali and Nazimuddin. Lord.
Two persons.
Two parts. Sections are all IPC sections.
Yes, Mr. Bharadwaj.
Lordship, Deputy SBI, he is in court number 1. So Lordship, may the matter be taken after some time.
Oh, this is the last matter. We have one more matter, Mr. Dekas, if the other side is there. Mr. Datta, you have for which matter?
Victim number 3. My lord, my name has not been shown, means, my lord,
Three has been passed over on the.
counsel who has engaged me, they did not give my name and they also remain absent. And ultimately, my lord, I am in embarrassing.
Death reference.
No, my lord, it's relating to,
Item 3 is a death reference, perhaps not in dispute.
I think they have wrongly instructed me,
Perhaps not in this case.
possibly. No? Or tomorrow, my lord, I'm sorry.
Mr. Deka, your other side is there.
I forgot.
You take the brief of one of the case on the other side. Both the counsel will be there.
Yes.
One party is there for two cases. What can be done, Mr. Bharadwaj? Should we allow her to start?
Yes, Lordship.
Provided he comes to around a short time. Otherwise, we cannot spill over the matter.
Lordship, let the appearance side start over the matter.
Okay, that is good. That we can do. But ensure that he comes. We cannot spill over the matter.
Yes, Lord.
Lordship, the appellants are in jail since.
You are Jideka, madam.
Yes, Lordship. They're in jail since 15/9/2022 and 2 years, 6 months behind the jail. In this case,
15/9.
15/9/2022.
Yes,
In this case, charge sheet was filed on 4/6/2022 against 6 accused persons.
4622.
Yes, Lord.
She has filed.
6 against 6 accused persons.
Hmm.
Then first supplementary charge sheet was filed on 16/9/22 against 1 accused person. And then on 13/12/22 against this both the appellants, charge sheet was filed.
30,
13/12/22.
3012,
1/3.
1312.
Yes, Lord.
Second supplementary.
It's the second supplementary charge sheet that was filed against the appellants.
Okay.
And the charge has been framed and against all the accused persons, same sections, Lordship. And the other accused persons, they all are enlarged on bail in this.
All other.
All are enlarged on bail.
The 7 are enlarged on bail.
7 are enlarged on bail. Under same section.
But this enlarging on bail is by the same order.
No, Lordship, different order. I have annexed the orders, Lordship. Annexer C.
No, even in this order, we have found that somebody has been enlarged on bail. Your bail has been rejected.
These appellants' bail were rejected,
But
Lordship.
somebody else's bail have been, I think.
No, Lordship, all the accused are enlarged on bail in this case. Annexer C series from page number 25, I have annexed the bail orders. From page number 25 to page number 41, C speaks. The bail orders of the other accused persons in this case.
Okay. Your rejection is 710.
Yes, Lord. And in this case, there are 2 victims, Lordship. Their examination is completed as PW1 and PW2.
How many PWs examined?
12 PWs out of 111.
Twelve examined.
12 examined out of 111.
Now, what is your case?
My case is, Your Lordship, bail may be granted
No,
as
why? Grounds.
grounds. Grounds as Lordship, the other co-accused have got bail on the same sections.
No, sections may be the same. What is the nature of your involvement? What is the nature of your allegation?
Allegations are same as the other co-accused, Lordship, and more particularly about appellant number 2. His name has not been reflected in the FIR, neither in the 161 statement of the victim, nor in the 164 statement of the victim.
Let us see the rejection part, why it has been rejected by 7/10/2024. Which paragraph?
Rejection part is it para number 8, page number 20.
20.
Upon perusing the charge sheet, may I read, Lordship?
Yes.
Upon perusing the charge sheet, prima facie there is existence of incriminating material against the present accused person. The nature of the alleged offense is also undoubtedly serious in nature with larger demographic implication. It prima facie appears from the materials in the charge sheet that the accused persons are Bangladeshi national. Here in para number, Lordship, in para number 5, in the rejection order, in para number 5, the prosecution has filed their objection for petition number heard the senior PP for the prosecution. It is stated and submitted that the investigation revealed that the above mentioned accused persons have been maintaining links with the other accused persons and human trafficking racketeers involved in anti-social activities. During the course of investigation, the NI has collected sufficient incriminating materials, evidences in connection with the instant case. They are having connectivity with the charge sheet as accused persons A1, A2, A3, A5, A6. All the accused persons are already enlarged on bail, and they have stated that they are having connection. And in the other side, as I stated, Lordship, in page number 20, because of the prima facie incriminating materials and as they may flee from justice, as they are Bangladeshi nationals, so the bail is.
Where is your domicile? Where are you from?
From Bangladesh, Lordship.
Hmm?
All the two accused persons are from Bangladesh.
Then how do you ensure her?
Lordship,
You are a foreign national
Lordship, the land documents are annexed here with
of
Bangladesh only.
land documents of Bangladesh. How will it serve as a security?
Lordship, they may be granted bail, they will stay here. They will do,
The others are also Bangladeshis.
no, Lord.
Then there's a vast difference.
But Lordship, without passport, they won't be able to go to Bangladesh also, Lord. They will stay here if bail is granted with proper conditions. Conditions may be imposed, Lordship. Only because they are Bangladeshis, bail is rejected.
It is not a offense relating to some passport violation or something else. It's a offense of much serious implication.
Lordship,
Human trafficking.
Lordship, I agree, Lordship, but the other co-accused are also like they got bail on the same section. Lordship.
Same section, but there is a vast difference. They are Indian nationals. That is why we had asked what is your domicile?
Lordship, we are agreeing we are Bangladeshis, but law does not differentiate between foreigner and a citizen.
Why? Law doesn't differentiate. Take the Constitution of India. How many fundamental rights are available to a person? How many fundamental rights are available to a citizen? Have you looked into?
Lordship, in this regard, I want to place a question, Lordship.
You look into the fundamental rights. Are all fundamental rights available to any person?
Lordship, I do agree, but simply because of that
See
reason, if they are
the nature of the allegation. It is not a mere some allegation of passport violation, overstay, or anything. Human trafficking. What decision you'd like to place?
yes,
Which one? The recent one?
2022, Lord.
22. There is a recent judgment Justice Oak has, in fact, delivered in the lecture also.
Lordship, I am relying on para number 41 and 42.
This is of which court?
Manipur.
Will it have any relevance? At least some Supreme Court decision, or at least of this court. This will only have persuasive value. And you are placing a single bench.
Yes.
Not proper. Do not place. There may be some Supreme Court decisions. Place it before us. But simply saying that other accused have been granted bail, we have been left out. That will not be the submission which will be sufficient to grant you bail. You have to make out a case independently. Yes, what do you say?
Lordship, actually, my instructions are that the appellate side finish their argument.
No, you have not gone through the brief.
No,
Go
yes,
to the brief.
Lordship. Actually, the charges are framed. These accused persons have been charged in the second supplementary charge sheet.
Correct, she has already stated.
And the charges were framed against them on 19/4/23 under section 120B, 373, 375.
19/4/23.
Yes, Lordship. 19/4/23.
Charges framed.
Charges were framed. 14AB Foreigners Act, under section 3 of Passport Act, Rule 6 of Passport Entry in India Rule. And Lordship, there are victims who have identified these accused persons,
Victim means?
victims who have been trafficked here. There are two girls. They are charge sheeted witness number 106 and charge sheeted witness number 107. And during the trial, they also deposed against them, and a TIP has also been conducted where these victims have identified these two accused. And Lordship, during the trial, PW1, Zubeda Begum, her examination was done on 14/6/23, and her cross-examination was done on 10/7/23.
PW?
PW1, Zubeda Begum.
She is also a victim.
Yes, and she is also a charge sheeted witness number
Doesn't matter.
107.
She had also identified the appellants in the TIP.
TIP and also in the dog.
In the dog.
Accused dog. And the other one is PW2, Dilkhash Begum,
106.
106, and PW2.
Yes, 107.
No, PW1 is 107.
Yes.
PW2 is 106. She was examined on 14/6/23, same date, Lordship.
Okay. Right.
And cross-examination is also on the same date.
Yes.
She also part of the TIP, where she identified these two accused.
What is the
persons.
name of PW2?
PW Dilkhash Begum.
Dilkhash.
Dilkhash Begum.
Identified
Identified.
on the dock.
Not on the dock, but she identified during the TIP. And PW1, she identified in the TIP and also in the accused dock. The second supplementary charge sheet was filed on 13 December 2022.
Yes, said second supplement against these two appellants.
These two accused persons. They were Bangladeshi nationals, both of them. And serious allegations were against them.
See the addresses. The addresses of Bangladesh. Who will give the security? So far as Indian nationals are concerned, suppose one person from Kerala is arrested to. So the Supreme Court has said you should not insist on local security. But here it's not a question of local security. It's a foreign national. What kind of security can you ensure?
They are having, if any condition may be imposed,
No, tell us
local
security.
security,
Surety. Who will give the surety?
local security, they will give,
Who?
they have certain people with who they know.
May not be fit case.
But more particularly, the victims, the medical examination of the victims were also not done here in this case.
No, we are not on the merits. We are on the prima facie view. This you can argue in the if there is an order of if the trial culminates in an order of conviction. You may be also successful in the trial. that charges have not been able to prove, but prime officer, if you go,
They are having minor children, lordship. 2 years, 6 months, they are behind the bar. And only 12 PWs have been examined out of 111. So how long it will take for the trial to get completed?
offense are also of that nature that may not call for heard. Ms. G. Deka, learned counsel for the appellants, as well as Sri A. Bharadwaj,
E Bharat,
D. Bharadwaj, learned standing counsel,
public prosecutor.
learned public prosecutor, NI. Para. The present appeal has been preferred under so-and-so of the National Investigation Act 2008 against an order dated so-and-so passed by the learned so-and-so. By the impugned order, the prayer for bail of the appellants has been rejected.
Kindly, section 19, at least day-to-day trial can be directed as per section 19 of the NI Act, if rejected, so that the trial gets completed.
And I. Ms. Deka, the learned counsel for the appellants, please have your seat, has submitted that the appellants were taken into custody on 15/9/2022, and since then they are behind the bars. She has also submitted that originally the charge sheet was filed against 6 persons on 4/6/2022, followed by a supplementary charge sheet against one accused person, which was done on 16/9/2022. Thereafter, a second supplementary charge sheet was filed on 13/12/2022, implicating the two appellants. Full stop. It is submitted that other than the two appellants, the other accused persons have been enlarged on bail. Full stop. It is submitted that since the charges are common in nature, comma, rejection of bail of the appellants by the learned special court is arbitrary. Full stop. Para. She has also submitted that out of one numbers of public PWs cited, comma, only 12 numbers of PWs have been examined, and there is likelihood of prolongation of the trial. Full stop. The learned counsel accordingly submits that the instant appeal be allowed and bail be granted to the appellants. Para. Per contra, we record whose name? We have recorded his name. Oh. Per contra, Sri Bharadwaj, the learned PP, has submitted that the projection made by the appellants are not wholly correct. First of all, he has clarified that though the other accused persons have been granted bail, they are all Indian nationals, whereas the two appellants are Bangladeshi nationals, and this fact is not in dispute. Full stop. He has further submitted that during the investigation, a TIP was conducted and two charge-sheeted witnesses being numbers 106 and 107 have identified the two appellants. He has further informed that on 14/6/2023, charge-sheeted witness number 107 was examined as PW1, and she has identified the two appellants on the dock. Full stop. He has also informed that the charge-sheeted witness 106 has also been examined in the meantime as PW2. Full stop. Para. On the nature of allegations, comma, it has been submitted on behalf of the NIA that the charges and allegations are grave in nature, which involves human trafficking, and PW1 and PW2 are two of the victims of such human trafficking. Para. The rival submissions have been duly considered. Para. It is not in dispute that the two appellants are Bangladeshi nationals, and the same has also been admitted in the memo of appeal itself. Full stop. Though the learned counsel for the appellants has placed much emphasis on the ground that the other accused persons have been granted bail, comma, we are of the considered view that there is a huge difference on the status of the other accused persons vis-a-vis the two appellants. Full stop. While the other accused persons are Indian nationals, the two appellants are Bangladeshi nationals. Full stop. We have also considered that PW1, Jubaira Begum, in her examination on 14/6/2023, has identified the appellants in the court, and such identification was also done at the stage of the investigation in the TIP conducted. Full stop. Para. Though, be that as it may, comma, this court, we are of the view that at this stage, the consideration is only on the prima facie aspect, and making any further comments may cause prejudice to either of the parties. Full stop. Para. Taking into consideration the facts and circumstances and the discussions made above, comma, we are of the view that no case for grant of relief has been made out. Full stop. The appeal accordingly stands dismissed. Full stop. At this stage, the learned counsel for the appellants has drawn the attention of this court to section 19 of the NIA Act 2008, which lays down that the trial by the special court is to have precedence. Full stop. We accordingly request the learned special judge conducting the trial to take into consideration the aforesaid provision of law and conduct the trial expeditiously. Okay. Record the scan copies. Report the rival conviction. The scan copies that I will consider. The scan copies of the TCR have also been perused.
Apply.
Other side,
Yes, my lord.
yes, Mr. Six.
May I please, your lord? I am the applicant before the wife, my lord. In case, my lord,
You're agreed by what? Grant of divorce?
Lord, yes, grant of divorce, I am not, and divorce granted, my lord, on cruelty and desertion, lord. The cruelty ground taken by the respondent that
Paper book is there.
I, my lord, yes,
Paper book is there.
sorry.
How many witnesses?
My lord, 3 witnesses from the PWs and 2 witnesses, me and my daughter, DW.
For 5 witnesses.
Five, yes.
Have you given the
I,
extract?
yeah, I have annexed all the evidences here, my lord.
Okay. And any other material witnesses, material evidence?
Material evidence, my lord, since this evidence is only discussed.
No, any documents or anything?
Exhibits, my lord. It's
No,
not nothing.
Nothing. Then if you are agreeing, then we can go ahead with this. If the documents are there.
Before taking the imperial judgment, my lord, I'll have to little synopsis of the case, my lord. Yes,
Yes.
my lord. While granting the divorce petition, initially before he filed a respondent by divorce petition